Massachusetts had a huge change in the alimony law in April 2012. Up until that point, alimony was generally lifetime alimony. A payor spouse would have to pay alimony until their death, or sometimes in an agreement it would say that alimony would terminate upon retirement, but not always. Sometimes there was no end date. So what the new alimony law, that's what it's just being called generically, is that it sets term limits on the time limit for how long alimony is payable. And that's entirely dependent upon how long the parties have been married. So there is a breakdown for 0 to 5 years, 5 to 10 years, 10 to 15 years, and 15 to 20 years. And so what they take is the number of months you've been married, and the percentage goes from, it starts at 60% and goes up from there of the number of months married that you have to pay alimony for. So after 20 years, it can be an indefinite term. And the caveat to all of this is that the judge looks at the ability of the party who's paying alimony to pay the alimony and the needs of the recipient party. So if the recipient party does not have the need for alimony for whatever reason, then alimony might not get paid. But we're talking a case where the more usual case where someone's been the breadwinner throughout the marriage and someone else has a lesser earning capacity. And in that sense, generally, the new alimony law would apply. So the other part to the term, and again, if you've been married longer, you have to pay a certain percentage based on the number of months you've been married. So it varies with the length of the marriage. And the length of the marriage is computed from the date of the marriage to the date the divorce is served. So, for instance, I recently had a case where they were just on the cusp of reaching the 20-year mark, and we wanted to get them in the 15 to 20-year category. So we had to get service done, and we did get service done, a week before the 20th anniversary. So the other thing to know with alimony is that, again, everything in this area is general, but the way it's computed now is that they take what's known as the disparity of incomes. So they'll take the payor spouse income. So just for example, say the payor spouse makes $90,000 a year. And they'll take the recipient spouse income and say the recipient spouse makes $10,000 a year. So if you subtract those two, you get $80,000. And then the alimony that's paid annually would be between 30 to 35% of that disparity. So the alimony paid to the recipient spouse would be 30 to 35% of the $80,000. And those are the rules regarding alimony, and when alimony can be modified and when people who had lifetime alimony agreements can modify their alimony depends on whether or not they've agreed at the outset when they got divorced that they had a surviving alimony clause, which meant that it's not modifiable, because there are people trying to modify lifetime alimony agreements, but they can't because they agreed that it would be non-modifiable. And the right to modify also depends on how long it's been since your agreement was entered into, because the alimony law is grandfathering those people in so that they do have the right to come back to court if they have a merging alimony clause.